All right, we're on the record.
Thank you. Good afternoon, everyone. My name is Judge D'Angelo. I am the single justice for this afternoon's sitting. We are calling the case of 2023-J434. Can all counsel hear and see me okay?
Yes, Your Honor.
Okay, great. All right, so with that, this is technically the Commonwealth's appeal, so I'll hear from the Commonwealth.
Thank you. Mary Murray for the Commonwealth. The Commonwealth asked the court to stay the petitioner's discharge pending the Commonwealth's appeal because the Commonwealth presents meritorious arguments that have a substantial likelihood of success on appeal, and because of the threat to public safety that the petitioner poses should he be discharged. Starting with the errors of law, the Commonwealth contends that the Superior Court erred by permitting the petitioner to raise by his petition for writ of habeas corpus issues not raised on direct appeal. And the court further erred by applying case law applicable to writs of error, not petitions for writs of habeas corpus. Secondly, the court erred by finding the commitment to be unconstitutional when Johnstone was not a constitutional holding whatsoever. Johnstone was a matter of statutory construction, which the SJC said and has reiterated 3 times. Further, the constitutional requirement is only that the Commonwealth present expert opinion. That requirement was established no later than 2000 in Bruno, 2 years and 1 month before the trial at issue in this case. And the trial judge had expert opinion, the expertise of the testifying witness for the Commonwealth not being challenged, nor could it have been, since he himself was a qualified examiner and had many, many years of experience evaluating sex offenders. And the third issue is by concluding that neither qualified examiner opined that the petitioner was sexually dangerous when Dr. Murphy, one of the qualified examiners, said, if I were permitted to consider the uncharged conduct, which was later proved at the trial, which the trial judge, Judge Healy, found beyond a reasonable doubt, then he is sexually dangerous. So first, the petition for writ of habeas corpus cannot be a substitute for a direct appeal. Mr. Pierce elected not to file a direct appeal in a timely manner. He elected instead to flee the Commonwealth and live as a fugitive. When he was apprehended and returned to the Commonwealth, he attempted to file a notice of appeal. That was struck by the court on the Commonwealth's motion, the district attorney's motion, and he did not appeal from that. So with all of that, and when looking at Johnstone, the SJC specifically said in McIntyre, which was tried in the same year as Mr. Pierce's trial, that they considered Mr. McIntyre's attack on that judgment because it was on direct appeal. Nothing in Johnstone, nothing in McIntyre or any other case that I have identified, that the the Superior Court here identified, or the petitioner has identified, indicates that it can be used to collaterally attack a judgment that was long final. Nothing in Green and nothing in Chapman, later decisions, changed that. In Green, the court said the constitutional requirement is for expert opinion. Johnstone said, as a matter of statutory construction, some of that expert opinion has to come from a QE acting in the capacity of a QE. Chapman didn't change that. The SJC's 2019 decision in Chapman did not change that. And due process is not offended here. There was expert opinion then, and the Commonwealth is prepared to proceed to trial on Section 9s. In fact, it was Mr. Pierce who got his Section 9 petition, which was scheduled for trial on June 5th of this year, postponed and elected not to be evaluated by qualified examiners at that time. Now, the court, of course, has the full record and of what the filings were below. And as the court can see, in an earlier Section 9 petition, which did not go to trial because Mr. Pierce didn't want to, qualified examiners evaluated him and said that he was sexually dangerous at that time. Turning to the next issue, which is the likelihood of irreparable harm, the Commonwealth has a substantial overriding compelling interest in protecting public safety. Mr. Pierce suffers from pedophilic disorder. He has a mental abnormality, which even the Community Access Board this year said. Once the harm is done to a child, that harm cannot be undone. And the Commonwealth is particularly concerned about Mr. Pierce's great-grandson. The grandson lives in the home where Mr. Pierce intends to live, according to the materials in the record here, and has a parenting plan with his own 8-year-old son. Mr. Pierce has offended against victims as young as 5 and continuing into their teenage years.
Counsel, if he is released, he will be supervised by the probation department. Isn't that correct?
He does have a period of probation, 10 years, yes, with no GPS and no unsupervised contact with minors. However, I would invite the court's attention to the fact that Mr. Pierce did sexually offend with other adults in the home, including his wife, offended in his own home against family members over a protracted period of time. In the instance of one of the boy victims, one family member victim, and adults were in the home the night of the 1997 offense that led to the conviction and the incarceration, which then led to the SDP commitment petition. So being supervised by probation did not prevent Mr. Pierce from fleeing in the first place, and being around adults did not prevent him from offending against children. So in the Commonwealth's opinion and view, that would be an inadequate substitute for continued commitment during the appeal. Further, he's a flight risk. He fled. He fled the Commonwealth and he successfully evaded detection and arrest for more than 2 years. And importantly, on the way out of town, as he's fleeing, and he fled because he knew he was going to be civilly committed. As he fled, he committed new crimes. One, he failed to register as a sex offender. So any reliance on SORB registration and notification, I suggest, is misplaced. And I'll talk more about SORB in just a moment. 2, he threatened one of the males who had testified at the initial commitment trial and was convicted of threatening to commit a crime and intimidation of a witness. Those were the crimes he committed on the way out of town. And then, of course, as the court knows from the record, he was charged while he was a fugitive and later convicted of sexual crimes against one of those males for whom the crimes were still within the statute of limitations and convicted after a jury trial. I also considered the harm to Mr. Pierce, should he be held. The timing of all of this rests squarely in Mr. Pierce's hands. He chose not to stay an appeal. He chose not to appeal from the order dismissing his appeal, striking his notice of appeal in 2005, 2006. He chose not to bring any matter forward, even for the 14 years after Johnstone was decided in April 2009. He waited until months.
He was serving a criminal sentence. Isn't that accurate?
Yes, he was. But if he thought he had a legitimate challenge, he could have brought a declaratory judgment action, which is entirely permissible under the Sargowitz case. He could have moved for a new trial. He could have taken all sorts of steps earlier. And he elected to wait until months after his criminal sentence expired to bring this habeas petition. So any issue of the timing and the delay rests squarely with Mr. Pierce, entirely with Mr. Pierce. And he had several options and junctures along the way. And it's not as if he was without counsel, because as the court understands from the Commonwealth's filing, he's had 5 Section 9 petitions and he's been represented by employees of Committee for Public Counsel Service who have worked in the office, the unit dedicated to sexually dangerous person matters. So he has not been out on an island by himself, not to be at all cavalier. But this could have been resolved months, years, decades ago, had he brought it forward. So with respect to all of that, also there's great reliance on his age and his medical condition. He lives in general population at the Massachusetts Treatment Center. He has said he plans to be out volunteering in a food pantry or a soup kitchen. He says he plans on being out walking. This is not a person who is incapable. And at the risk of belaboring a point, this is an individual who has offended against family members and people he encountered right in the area of his own home. A neighborhood boy delivering papers, another boy he encountered at a part-time job. So with all of that, it's the Commonwealth's position that Mr. Pierce should remain held. I did want to touch on the Community Access Board opinion that Mr. Keneally mentioned in his papers. One, the CAB did not have the benefit of an interview with Mr. Pierce. And there's no indication that they knew that the home environment included a grandson who had a great-grandson in the mix, a parenting plan with him. There's no indication, and I specifically reference the appendix, volume 2, page 362. They had gotten the information that no minor children were residing in the home. And I don't know whether the minor child resides in the home, but he certainly, the person who has a parenting plan with him does. The CAB majority also indicated that Mr. Pierce has a very limited understanding of his deviant sexual interests at this time. That's on page 362 of volume 2. That he has pedophilic disorder, which is a mental abnormality, pages 362 to 364. And as the CAB minority noted, he doesn't understand his deviant sexual interests, and that combined with the lack of progress in sex offender treatment considerably outweigh any protective factors, written by Dr. Holtzen, himself as a licensed psychologist. So with all of that, and I would suggest Mr. Keneally has referenced the case of RB, which went to the SJC and resolved essentially 2 strains of case law about whether, a claim not raised below is waived or whether it is to be reviewed under substantial risk. But those claims were being made on direct appeal. Nothing in RB suggests that you can wait 2 decades and then raise a claim after the time for appeal has long since passed. So one other point about sex offender registration. At the time the papers were filed below, it was the Commonwealth's understanding that he had not been finally classified. I will mention this to the court, although it is outside the record, is my understanding he's been classified as a level 3. However, I do not know because SORB proceedings filed in the Superior Court are not public. I do not know whether there are any pending challenges to it, but in any event, the Sex Offender Registry Board, contrary to Mr. Keneally's assertion, does not set limitations. It merely classifies and it provides a registry. I don't minimize the importance of the SORB's work, but they do not decide what conditions anybody would be subject to. And certainly a level 3 classification by SORB does indicate that an independent state agency has found him at the highest risk to reoffend, the highest level. But more importantly, we don't know whether Mr. Pierce, I don't know, I should say, if Mr. Pierce is challenging that classification. As I mentioned, those proceedings are impounded in the Superior Court. But we can take notice of the decisions of this court, that SORB decisions, SORB challenges can often take very, very long time to be decided, during which time there may be no public notification. And I would invite the court's attention to the Doe case at 473 Mass, where there was at 297 in 2015, where there was an order to cease disseminating information pending reclassification proceedings on remand. In another SORB case, 97 Mass App Court at there was the SORB proceedings of a released SDP began in 2009, continued for more than a decade, and led to a 2020 order vacating a level 3 classification and a remand. Similarly, in March of this year, another SORB case is an unpublished decision, but a released SDP who was released from custody in 2010 had 4 de novo hearings before the SORB over the course of 11 years. So SORB registration, in addition to the fact there's nothing in the record here, and the Moe case from the SJC certainly suggests no indication that dissemination of information precludes, has stopped sex offending, even though the SORBA undoubtedly does important work. So for all of these reasons, the Commonwealth's likelihood of success on appeal, raising meritorious issues, the significant threat to public safety, there is no harm to the public interest. In fact, it's in the public interest to retain Mr. Pierce in custody. And finally, the issue of his liberty, frankly, while the Commonwealth certainly recognizes the significant liberty interest in a continuing commitment, the timing of all of this and the fact that it's taking place after the conclusion of his criminal sentence, when he had many options and many avenues along the way, and a continuing right to seek discharge on a Section 9 petition, on balance, the factors all weigh in favor of a stay. And for that reason, the Commonwealth asked the court to continue the stay pending the Commonwealth's appeal. And the Commonwealth is prepared. In fact, the appeal has been docketed in this court. The Commonwealth is prepared to proceed on an efficient, straightforward basis. Mr. Keneally and I have already agreed to the contents of the record. And I think that the case is ready to proceed. The Commonwealth's brief is due, I believe, September 25th, and the Commonwealth's prepared to proceed on that basis without any anticipated delay.
Attorney Murray, have you and Attorney Keneally had any discussions about going into the Superior Court on a joint effort to try to get probation conditions modified to satisfy some of the safety concerns that you might have?
There's been no discussion of that, nor would I suggest to the court. I think I have to suggest to the court the limits of my authority to represent the Commonwealth. I do not have the authority to represent the Commonwealth in the underlying criminal proceedings. That would be the province and purview of the district attorney's office. There have not been. I was prepared, and I will tell the court this. Mr. Pierce, as I mentioned to the court, elected not to go forward with the QE evaluations. I am prepared to discuss with Mr. Keneally and the trial attorney for Mr. Pierce. The trial was postponed to 2025. I am prepared, based on the Community Access Board's report, which is something that we do from time to time, to inquire about expedited qualified examiner reports. Because if the qualified examiners evaluate Mr. Pierce and they determine he's not sexually dangerous based on the full record, including an opportunity to interview if he elects to participate, the Commonwealth is prepared to do that. I was fully expecting such a request after the CAB reports, I should say, were done. The Commonwealth is fully prepared to have that done. And in fact, we've done not on a habeas, we haven't had a habeas case in particular, but in similar circumstances on a number of occasions, we have agreed to expedited qualified examiner evaluations. If the qualified examiners opine that he's sexually dangerous, or one does, then the case can be, try to put it into a trial queue for an available date. And if not, then of course he would be entitled to release without a trial under Johnstone. And the Commonwealth was well prepared for that, but I have not received any inquiry on that point. But I stand by it, and I stand ready for that. And the usual time frame for a qualified examiner report on an expedited basis would be typically, and I don't know of anything barring it here, but would typically be around 45 to 60 days, which would be something the Commonwealth is willing to engage in.
Thank you very much. Attorney Keneally, I'll hear from you.
Good afternoon, Judge. Attorney Joseph Keneally for Mr. Pierce. To start, Your Honor, one thing I would like to bring up, I know that Attorney Murray has mentioned that Mr. Pierce was responsible for the years, decades delay that occasioned this litigation here. I would point out that Mr. Pierce was determined to be sexually dangerous in 2002. The Johnstone case was decided in 2009. The Commonwealth at that point had to have known, or should have known, particularly since the attorney who did his initial sexually dangerous persons proceeding worked at the treatment center with the legal department, had to have known that he had been committed in the absence of a qualified examiner opining that he was sexually dangerous. And at that point, the Commonwealth, in fact, could have done anything in those intervening 13 years prior to the wrapping up of Mr. Pierce's sentence to have sought a declaratory judgment either through them or the Plymouth County District Attorney's Office, declaratory judgment indicating that the commitment order was invalid per Johnstone, could have had him remanded back to serve the rest of the sentence, at which point, when the sentence expired, could have filed a sexually dangerous persons petition. They had 13 years to do that, and they didn't do anything. Instead, they want to put it essentially in the lap of Mr. Pierce, who, I know he has counsel, but there's no indication that he even understood what the principles of Johnstone even meant or where he was going to go with that. So in terms of the years of delay that are occasioned here, I think putting it on the lap of a 70-year-old man who barely has a high school education seems a little bit odd. Now, in terms of the merits of the Commonwealth's appeal, I think that this issue is a lot less complicated than the government makes it. In 2002, Mr. Pierce was committed as a sexually dangerous person in the absence of any qualified examiners opining he's sexually dangerous. 7 years later, in the Johnstone case, the SJC said that a commitment in the absence of at least one qualified examiner saying an individual is sexually dangerous, the evidence is insufficient as a matter of law to support an SDP finding. There's no indication that that doesn't apply retroactively because it's a matter of interpretation of the statute at the time it was enacted. And because at the time that Mr. Pierce filed his habeas petition, and after he wrapped his sentence, the only alleged basis for his continued commitment was the unlawful civil commitment order. Now, the Commonwealth has not disputed any of these facts, and it is upon these facts that the judge decided this case. He was found to be sexually dangerous in the absence of a qualified examiner. That's an illegal judgment. The only thing holding him was the illegal judgment. That's why he filed a habeas petition. He was ineligible to file a habeas petition until the point where he was being illegally detained when his sentence lapsed. That's what he did, and the judge in the lower court found that there was no impropriety in him doing that. Now, in terms of waiver, the Commonwealth seems to suggest that, yeah, well, we fought tooth and nail essentially to prevent you from being able to appeal in 2005. And since we won that fight, now you have to live with it and you have to remain incarcerated as a result of not being able to appeal. I would suggest that it seems a little odd that the government in 2005 essentially said you have no right to appeal this judgment, but is now 20 years later saying you absolutely have waived it because you didn't go forward and appeal. Now, I would submit that in some circumstances, a waiver actually does prevent any sort of appellate remedy subsequently. But these are not normal circumstances because the petitioner's liberty is at stake here. And this happens in a lot of contexts. For example, if someone is convicted of a crime and incarcerated based on evidence that was not sufficient to support a conviction, he doesn't just waive his right to do anything about it if he is being deprived of his liberty. His claim will certainly be subjected to a heightened level of scrutiny. He can bring an ineffective assistance of counsel claim for his appeals lawyer's failure to pursue that, which essentially is evaluated under the substantial risk standard. It's functionally the same thing. And the reason why is because if someone is being deprived of their liberty based on an illegal order, the courts in Massachusetts do not just sit in their hands and say there's nothing that can be done about that. Not when someone's freedom is on the line, and that's what the case is here. And that's why the RB case, 479 Mass 712 in 2018, said that it's a substantial risk the waiver standard applies to sexually dangerous persons proceedings. In addition to that, there's a simple fact that Mr. Pierce did not waive this claim because it wasn't until the Johnstone decision came down in 2009 that it even became an issue. Prior to that, this was an open question. There's nothing to suggest that that this sentence, that his commitment was illegal on that basis. Now, I suggest that that's pretty much it. That's the issue here. I mean, there was a lot of talk about writs of error, writs of habeas corpus, and constitutionality and stuff like that, but ultimately it comes down to he's currently being held on an illegal sentence, and the Commonwealth has not disputed that. Now, as for the second and third parts of the test as to whether the Commonwealth is going to suffer irreparable harm as a result of not getting the stay, virtually the entirety of their argument is based on information and things that happened at least 20 years ago. Commonwealth points to offending that happened from 25 to 50 years ago, and they refer to his fleeing the jurisdiction in 2002. There's nothing here that they're suggesting when it comes to his dangerousness that is any more recent than 20 years old. However, as pointed out, mere months ago, a majority of the CAB, including 3 out of 4 of the forensic psychologists who evaluated him, determined that he was not sexually dangerous anymore. And they said he has, I'll quote, he has numerous medical issues, including diabetes. He walks with a cane, congestive heart failure. He reports having family support and 10 years probation from and after. He's engaged in treatment and is making progress. He's behaviorally stable, has 2 OBRs during his 20-year commitment. OBRs, of course, are disciplinary reports at the treatment center. It says, furthermore, he committed his last offense 25 years ago. Okay, this is the most current observation of his dangerousness. Now, Attorney Murray will talk about things that happened 20 years ago, 50 years ago, something along those lines, but this is what they're saying currently. Now, there is a plan in place for him. He will have no contact with children. He will have no unsupervised contact with any children under any circumstance. If he does, essentially he will be in violation of his probation. He'll be remanded to finish his sentence, which essentially will be at least 5 years in prison, and after which the Commonwealth can again file a petition for civil commitment. So ultimately, if he violates his probation, then he will be spending the rest of his life in prison. He is aware of that. Now, I've spoken to Mr. Pierce, and he has indicated that if in fact there is concern regarding a risk of flight, he is willing to amend the conditions of his probation and get on a GPS and get on the bracelet, so the probation will know where he is 24 hours a day. Now, given this, and given his age, there's no reason I would submit for him to spend the next several months waiting for this case to be resolved in the SJC or the
Counsel, if he's released, is he going to be living with children?
No, Your Honor, he is not. The current plan is that there have been arrangements made for him, and this is actually different than what I had originally stated in my motion, because circumstances have changed. What the circumstances are now is he will be staying at the Elm Court facility, which is in Brockton. It's a place that houses several individuals like that. He'll be staying there essentially to sleep. His daughter will pick him up in the morning, keep him at their house, and take care of him throughout the day. And he will be dropped back off there in the evening to go to bed. On the weekends, if there's any presence of children in the house in Brockton, he will not be there. He will be returned to the Elm Court Hotel, or he will stay outside of his outside of the home, where he will not have any contact with any kids. The plan here is not simply to avoid unsupervised contact with children, it's to avoid contact at all. Mr. Pierce is 72 years old. He walks with a cane. He does not have his driver's license. He does not intend to get a driver's license. His daughter has represented to me that, in fact, she will be able to take him to whatever appointments he needs to go to in terms of doctor's appointments and those sort of things.
Attorney Keneally, let me cut to the chase.
Sure.
From my perspective.
Mm-hmm.
If all of the things that you just said were agreed to by the Commonwealth, and I mean the District Attorney's Office, Ms. Murray, and those were put into position of his probation by agreement, that would certainly satisfy me regarding prongs 2, 3, and 4, frankly, of what I have to look at, which is the concern for the public, concern for the petitioner, and whatever the other one is. I don't have it in front.
Public interest.
Public interest, because that would satisfy all 3 of those. So even if I found that there was a likelihood of potential success on the appeal, I would say that the Commonwealth hadn't met their burden on 2, 3, and 4 if those probation terms are put into place. But as I have it right this minute, they aren't. So what would you suggest I do?
Well, I would suggest, Your Honor, that Your Honor stay his release until I can confer with counsel, his trial counsel, There are a number of attorneys who work on Mr. Pierce's case. In STP case, there's always the appeals lawyer and there's the trial lawyer. As the appeals lawyer and generally in appeals counsel, I don't deal with probation all that often, unfortunately or unfortunately. In any event, I would confer with counsel. We would immediately file a motion to amend the conditions of probation. If this court were to order exactly the conditions that it would find satisfactory.
I don't think I can do that.
Okay. Well, given the understanding here, and given what I've represented, if the plan that I've represented is acceptable to this court, then that will be offered to the Plymouth County District Attorney's Office as a motion to amend the conditions of this probation.
The concerns that I had, which I think you were very successful in alleviating, are him living with children, him being around children, and not being on GPS, which is pretty much everything Attorney Murray talked about in a nice appellate way as to how she would get over the problems regarding prongs 2, 3, and 4. So I would be very happy to stay any decision on this. I'm trying to think whether I should put a time frame on it or whether it should be until a status is provided to me by counsel. And Ms. Murray, I certainly understand the Commonwealth, meaning your part of the Commonwealth, may not be in agreement to anything. I firmly get that. But it sounds like Attorney Keneally might have to, it certainly would be easier and quicker if the DA's office goes along with it, because these would be more stringent conditions of probation than he's actually going to be on if released. So they might be in agreement to this. I don't know. But if it came back before me with those conditions all put on his probation in the criminal case, the probation part of it, I think that would probably satisfy me, and I would be willing to stay it. Should we say I'll stay it pending a further status from the parties or from you, Attorney Keneally?
Certainly, Your Honor. I cannot draw the Plymouth County District Attorney's Office into this right now because obviously they're not here. And the furthest thing, last thing I do is represent their position on this, obviously.
I get that.
However, what I could do is I could get a motion to amend the conditions of probation consistent with this hearing immediately. And if there's not I'll file it and send it to the District Attorney's Office. And if there's no response immediately, I will keep this court apprised as requested, up to date as to the progress of that motion.
That sounds great. Attorney Murray, did you want to say something?
A couple points. Yes. First of all, whatever status is being filed, the Commonwealth would like an opportunity to respond to the court.
Sure.
So some time frame for that. The other issue is to point out something a couple points Mr. Keneally made. One is the issue of the lack of a QE opinion was raised by Mr. Pierce's trial counsel.
Attorney Murray, there's no rebuttal allowed. I'm not going to, if there's anything regarding the conditions, sure, I'll let you be heard on that, but not as far as the main argument, because we don't allow rebuttal.
Sure. So I, as said, the Commonwealth would like an opportunity to look at that, respond to that, and be heard further. That's fine.
So what I will do is, for procedural purposes, I am going to continue the stay pending a status report by the parties. Whenever I get the status report from Attorney Keneally, I will certainly make an order at that time, allowing the Commonwealth a very short time to respond to that. And then I probably will not have a further oral argument. I will probably make a decision on the papers. Okay?
Understood.
All right. Thank you all